And that was the CMA's position. The CMA's position was you do have to conduct the assessment. You have to calculate the permitted range in the correct way. You have to use the relevant elements, and you have to. I mean, that's in a sense obvious, but that was the position. So that's the one legal obligation. The second obligation is, of course, that which most directly arises under paragraph 8.237 of the CUSC, but also, as you've seen, has its indirect origin in the transmission licence between GEMA and the national grid. We don't need to turn it up. It's clearly an obligation to better facilitate achievement of, amongst other things, ensuring compliance with the permitted range. And it's under that provision that the relevant decision was made, and in our submission, therefore, that is the correct relevant legal provision that governs the legality of GEMA's decision. And it's that provision which ultimately was applied by the CMA, and I'll show you that in just a minute. But before I do, just very shortly, the point was obviously made to the court about the implications of the original position not being elected or not being chosen, and that would lead, or be very likely to lead, to a position of breach of the permitted range, putting the UK in breach of the regulation.
So why is that? I mean, I thought the hypothesis was that you could, in a sense, do what you want in terms of ex-ante charging, give or take. It'd be nice if you actually got the connection exclusion correctly defined, but you don't have to, because it'll all come out in the wash at the end of the year, and then you make an adjustment.
Well,
I mean, why would you therefore be in breach of anything? You can always adjust at the end of the year, just by question of by how much and what sort of problems it causes.
well, I suppose that in a sense that's right, but although there was clearly there was an assessment being done, and you've been taken to the provisions that record that in the CMA decision, there was a process of overseeing and doing the calculation, and that was in fact how.
Yeah, but what they were trying to do, as I understand it, is just we'll pick the option that gets us closest to where we think the end of year determination has to be, to minimise the amount of the adjustment we have to do at the end of the year.
There was no formalised mechanism for rebalancing at the end of the year, and so they were, they were in a situation where they were choosing between an option that would have remained within the permitted range and an option that would very likely have gone outside the permitted range, and that was the decision that GEMA were confronted with.
Did the decision following the TLR include, as part of its decision, that there would be an adjustment mechanism built into the new modification proposal? I'm not certain if there was at the time the process of reconciliation, but I'm sure I read somewhere that that was part of the decision, which was to introduce a form of a mechanism for adjustment.
Yes, I'll take instruction on that specific point if I may, and I'll get back to you on it. Can I just show you there's this table at 4.3 of the CMA decision, which is quite useful. I just want to just draw your attention to it because it's handy. Page 582, Core Bundle 3, tab 24. And
So which page one?
582.
582, excuse me. This is a table that was compiled by the CMA on the basis of data provided by GEMA. And I won't take you to it now, but for your note, there is a GEMA produced note that explains the table. It's a short 2-page note, and that's at SB2 tab 24. And it was described earlier today, this morning, the downward adjustment that is built into the status quo position and that was not built in to the either the original position or indeed the WAC M7 position. And you can see that if you see the three positions are set out under the heading formula on the left hand side. You've got the status quo, you've got the original position, you've got the WAC M7 position. And then if you go along to the column that has at the top E minus brackets C minus D equals E, you will see that's the downward adjustment. And so on the status quo, there's an enormous downward adjustment to the
that's the one
charges.
we were talking about that's done
Yeah.
at the end of the year.
Yeah, that's the downward adjustment that was done at the end of the year. And if you follow along the status quo position, you can see that that's projected to result in a position that is minus 83. And that's below the permitted range.
But that's below the floor.
Yes. And that, I think if you have it in colour, that's probably in red. And then the other two positions are within the permitted range. And the downward adjustments on those are, as you can see, very small. And they don't take you outside the permitted range. So they were the options. So, sorry, the 450 million downward adjustment is part of the ex-ante, of course, approach that's done under the status quo position, because that's an ex-ante assessment under the original position. Under the status quo position. So on the status quo position is an ex-ante formula that's applied. There's no ex-post approach. So that 450 million is what would be done under the status quo approach as an ex-ante assessment. And you can see that effect is projected to result in a position that's below the bottom of the permitted range. So that was the context in which the decision was made. And you can see from looking at that table very clearly that why GEMA were of the view that although it did not embody the correct interpretation of the connection exclusion, nonetheless, by agreeing to the original position, the original proposal, they would be ensuring that the permitted range was not breached. Now, what did the CMA say about GEMA's decision and how did they analyse it? I'll be very brief, but I can just highlight a few passages in the decision. First of all, 575, so we're now in Core Bundle 3, page 609, and this is in tab 24. There's a heading, the test. And this is the test that the CMA identified as being a relevant test that GEMA had to apply. And it says at 575, pursuant to National Grid's licence conditions, GEMA was required to take the decision by reference to whether the original position, and I quote, would, as compared with the then existing provisions of the CUSC and any alternative modifications set out in such report, better facilitate achieving the applicable CUSC objectives. And they refer to this throughout the decision as the better than status quo test. So that's the approach that CMA takes. Is the original proposal better than the status quo? and then it goes on, talks about 8.237 of the CUSC.
Can I just ask you about
Yes.
better facilitation? Better facilitation is not just better than the status quo. It's better than the status quo pending full resolution, isn't it? I mean, it isn't just, it's better than, yet still unlawful.
Well, as it happens, on the facts of this case, as I've just shown you, there wasn't going to be, or wasn't thought to be, any projection that would breach the permitted range. So, as it happens, on the facts of this case, there was a choice between a position that would not have breached the requirements of the regulation and a provision and an option which status quo, which likely would have done. Now,
But still,
but if the original proposal had also been going to result in a breach of the permitted range, then I think my Lord's question would arise. What would one do in that scenario? And that's not an issue we have to worry about in this.
the National Grid proposal took the charge within the permitted range, but it still left the question of the exclusions outstanding. So I think all I'm saying is, when it's not just better than the status quo in and of itself, if the better position still leaves something yet to be done, which is why the GEMA decision and the stopgap position is important. It then went that extra step and plugged that residual gap. But all I'm saying is, the better than the status quo isn't definitive or complete as a test, is it?
Well, what I'm trying to avoid is opining on a situation that hasn't arisen, partly because it hasn't arisen, therefore my clients haven't taken a position on it, partly because we don't need to go there. As it happens in this particular case, they were expecting another proposal to be brought forward, and they were expecting the position to be rectified and the erroneous interpretation of the connection exclusion to be rectified.
The GEMA decision is a bit more definitive than that. It's expressly conditioned upon a further proposal to ensure full compliance.
Well, they'd already made the direction. So they'd already made the direction after their code review, requiring a further proposal to be brought forward, and it should comply with the correct definition of connection exclusion. That then obviously had failed, so they were expecting a further one to be brought forward. And I completely agree that the decision here was premised on that occurring. All I'm doing is avoiding addressing what would happen if that wasn't the case, because it wasn't the case, and we don't need to speculate.
Let me take a scenario. Let's assume that the National Grid proposal was fractionally outside the permitted range, but still very much better than the status quo. Then what?
Well, that's an even better. Well, that's the scenario, my Lord, that I just offered to you earlier. I said that would be a situation that would be more difficult. We don't have to decide that. I mean, I can't give my Lord the answer, because it hasn't arisen and it hasn't been.
Your status quo test is simply a proxy for Articles 17 and 18 of the directive, which impose an obligation on a regulator to ensure compliance. You've slightly watered it down by saying better facilitates rather than ensure. Now, if you construe the two together, fine. But if you're saying that it permits the regulator not to ensure compliance, it might be different.
Well, if you've got another way of ensuring compliance, the obligation of making this.
But I entirely accept that, provided there is some ensurable compliance at some stage in some way.
Well, it may be, you see, my Lord, that the regulatory body might be in breach of, and this arose within the decision about those arguments about whether GEMA was abusing its discretion. Because it is possible that GEMA could take a lawful decision under the CUSC, but would nonetheless be in breach of EU law, directly applicable EU law. Those are potentially consistent scenarios because of the terms of the CUSC limit what GEMA can do in taking a decision under the CUSC. So you could end up with a situation, if for example GEMA hadn't been taking other steps, GEMA might have been in breach.
I'm not certain I see how you can be lawful under domestic law if you are unlawful under the regulation, which is EU retained law now, so it's domestic legislation.
Well,
And you'd have thought it's the superior rule which has to be complied with rather than some subordinate administrative discretion.
well, it depends if you've got two parallel ways you can achieve compliance. If there's only one way you can achieve compliance with something, then obviously the superior norm will override. But if you've got two ways you can potentially achieve compliance, yeah, not achieving it under one norm will mean that you need to use the other way of achieving it is in breach of that norm, but they're not necessarily inconsistent positions.
So I add a gloss to your point, which is provided you can achieve compliance by some other method.
Yes.
Okay, in which case, why are you in breach of the first one? You've just secured compliance.
So
And maybe this is all tautology.
yeah, I'm not sure how. I mean, it doesn't arise really on the facts of this case, which is perhaps why the CMA haven't grappled with this particular scenario. But I quite understand if there's only one way to implement a directly effective EU law, then if you don't do it, even if that involves overriding a contractual provision or a subordinate norm of public law statutory instrument, then of course you have to override that norm. But where you've got two different ways you can achieve something, that doesn't necessarily follow. So just to complete this, my lord, at 5.78, the CMA refer to the CUSC obligations, they refer to compliance with EU law. And then at 539, they say the better than status quo test falls to be applied at the conclusion of the modification process established by the CUSC. So that's the approach, that's the test that they identified. The decision is dealt with, it comes in at various places, but the point I would like to highlight starts at 632, and this is under a heading Our Decision, and in particular
Page 632 or paragraph?
it's page 632 at paragraph 5.144, and I won't read it all out, but for your notice, 5.144 through to 5.146. And in particular, but not exclusively, the beginning of 5.144, in considering the lawfulness of the decision, it's important to have regard to the test which GEMA had to apply under the relevant licence conditions, and I've taken you to where they've set that out. It was not simply, is this decision right? It had to apply the better than status quo test, which also involves considering whether the original proposal facilitated compliance with EU law. The appellants argued that an incorrect proposal could not be the best. This does not follow. And in my submission, that is entirely correct. And then if you go forward to 635 at 5.151, it is not enough for the appellants to argue that any failure fully to implement the correct construction of the connection exclusion vitiates automatically the legality of the decision. In our view, it's relevant to consider the context the onus is on them to show it's wrong. And as I've shown you there, they applied the test and considered that it had been satisfied. And can I, for your note, I don't need to take you there now, but can I also just ask you to look at paragraphs that arose under ground 2 but are also relevant at 7.09D and 7.12 at pages 686 to 688. Of the CMA's decision. Now, in terms of the approach of the judge, if I could just ask you to take up the judgment in Core Manual 1. Tab 13. We say that paragraph 37, that's on page 195, in the second sentence of paragraph 37, the judge correctly identifies the relevant legal obligation, which was to better facilitate compliance with the regulation. And indeed, if you turn forward to paragraph 40, he identifies that as the relevant obligation on national grid at paragraph 40. And it's important not to lose sight of the fact that the CUSC is maintained by National Grid, and it's the obligation under the transmission licence on National Grid to better facilitate the objective. And Ofgem, as it were, has a role under the CUSC in taking a decision as to the terms of the CUSC. But the obligation under the CUSC is in fact National Grid's, and the way it's expressed there at the beginning of paragraph 40, we say is in line with the analysis of the CMA. However, when the judge comes to apply it, the judge takes a different approach. And if you turn to paragraph 43...
Are you leaving 40?
I am leaving 40.
Is the judge right in the last sentence of beginning thus notwithstanding? Is he right in that sentence?
Well, part of the difficulty, I think, with that sentence is the one that was identified this morning, which is the Annex B doesn't really tell you anything about what specific generators should be charged. How you distribute the charges between generators in order to ensure the overall is within the permitted range is entirely a separate question.
I mean, throughout that sentence, I think you say confusing the purpose of an adjustment, sorry, the purpose of the charges and the adjustment tariff, in fact, and the test at the end of the day.
Exactly, my lord. And the Annex B does not tell you anything at all about how you distribute charges amongst electricity generators in order to ensure you're within the permitted range. Therefore, ergo, if you're outside the permitted range, it tells you nothing about how you redistribute.
I think you say it's a short step from misunderstanding, making that confusion, to saying that you actually have to incorporate the connection.
My lord,
to as part of the CUSC.
Exactly, but we say that part of the confusion is also when Mr. Justice Swift came to apply the analysis, he loses the obligation to better facilitate. That just drops out of the analysis.
Well, actually what it's replaced by is a view that you actually got to comply with the
Exactly.
correct interpretation.
Exactly. So, for example, if you turn to paragraph 43 and you look 5 lines down, the judge talks about the means to meet its obligations. So he's saying they've decided to bring forward CMP 317 and 327 as a means to meet the obligation of compliance. Yes. But then the end of the paragraph, so far as concerns the evidence before me, there's no suggestion there was any other route to compliance other than through the CUSC. Well, that's may be the case, but it doesn't follow that there couldn't be compliance by bringing forward another proposal to amend the CUSC. The conclusion, in those circumstances, the second proposition fails, doesn't follow from the premise, because it doesn't follow that because they've decided to implement through the CUSC, that it was unlawful for them not to accept the original proposal.
Does the CUSC only deal with ex-ante setting? It doesn't deal with end-of-year adjustment?
The status quo only dealt ex ante. The original proposal has an ex post reconciliation built into it. So the original,
sorry, my question was, he says that there's no suggestion that there was any other route to compliance with Regulation 838 2010 other than through the CUSC. What I'm saying is, in the paragraphs of the CMA decision we were looking at, it says you can do a lot of things at the end of the year to ensure compliance with the regulation, and they list a whole number of things that you can do.
yes.
Are all of those capable of being done through the CUSC, or does the CUSC only deal with the forward charging?
I'll need to take
Because otherwise he's there's the paragraphs you were just referring to.
Yes.
536, 537 of the CMA decision, where they say there's no barrier to ensuring compliance through a combination of ex-ante, in-year and or ex-post means.
Yeah.
For example, modification of the charging regime during the year, ex-post reconciliation measures, charges or refunds at the end of the year. What I was just asking is, and there's a whole host of suggestions there.
Yes.
If those are, how would they be done? I mean, are they through the CUSC? Has the judge has used that language? If so, is he just forgotten?
Can I just take?
Yeah.
So the short answer is yes, it's all done through the CUSC. There's a mechanism for bringing forward proposals, and they can be brought forward on an urgent basis. So yes, it can be done through the CUSC, but one has to bear in mind there's a difference between if you identify that you're outside the permitted range, what can be done in response to that, and ascertaining whether you're falling outside the permitted range. Because under the existing status quo position, that's only done ex ante. So insofar as it's done ex post, it's not done through the CUSC. So any reconciliation would then have to be done through the CUSC. If you look at the end of 44, the judge says the relevant applicable CUSC objective was compliance. And GEMA's decision did not secure compliance. And in my submission, that is a clear error on the part of the judge below, because the relevant applicable objective was not compliance. It was to better facilitate achieving compliance. And the fact that GEMA's decision did not secure compliance is therefore based on a faulty premise. As it happens, GEMA's decision ensured that their permitted range was not going to be exceeded, whereas had GEMA made the opposite decision and rejected all of the proposals, there was an imminent risk of breaching the permitted range. And finally, at the very end of 45, you see the same language coming in again. Actual compliance with Regulation 838/210 was what was required to permit GEMA to approve this aspect of the modification proposal. And in our submission, that's the key error here. The key error is that was not the relevant legal obligation.
Well, he's turned what was a qualifying obligation into an absolute obligation.
Yes. That's the key point we make. My Lord, in terms of the points about primary and secondary obligations, about process and outcome, my short point on that is they really probably cloud rather than enlighten, and I don't submit that anything turns on those distinctions. My Lords, those were my submissions.
Thank you very much.
My Lords, my submissions will focus on grounds 1 and 2 in the main appeal before moving on to deal with the cross grounds of appeal in that order with your Lordship's permission. On appeal ground 1, the first ground was addressed in our main skeleton at paragraphs 16 through to 32 and in our supplemental skeleton at 3 to 5. The first ground is essentially one of statutory construction, what is required by the Itc Regulation. But there is a preliminary point as to whether or not somehow Mr. Justice Swift has said, well, you have to have something in the CUSC. On that preliminary point, our submission is that the judge made no such finding. If one looks at paragraph 43 of the judgment, he recognised that as a matter of principle, it was open to a regulator to give direct effect to the directly applicable regulation without doing anything in the CUSC. The regulation, as is well known, is directly applicable. It's binding on the national regulatory authorities and indeed CUSC users. It's a primary piece of, it's a binding and directly applicable piece of legislation, certainly at the time that GEMA took the contested decision in December 2020. And as my Lord Justice Green has indicated, a decision has been made to retain the Itc Regulation as a form of retained EU law. But in this case, GEMA chose to use a modification of the CUSC to implement part of the Itc Regulation. And it made it clear in its decision letter that it was allowing the wrong definition of the connection exclusion to be baked into the CUSC, to be made formally legally binding between the CUSC parties, and it thereby became a condition of the transmission licensee's, National Grid, licence. Failure to comply with the CUSC would therefore be a breach of Grid's licence conditions, and it would not therefore, it would be at risk of incurring penalties in the event that it doesn't comply with the CUSC. So while Mr. Justice Swift in paragraph 43 recognised that GEMA could in principle have exercised another regulatory power to give effect to the connection exclusion and the requirement to conduct the calculation, it had not in fact done so. And I propose, with your Lordship's permission, to show you the evolution of approaches to dealing with compliance with the ITC regulation over time, albeit very briefly, to show you where we have landed where we have. Before doing that, there's been various suggestions of this simply being a contractual arrangement. With the greatest respect, that's not 100% accurate, because if one turns in Bundle of Authorities, Bundle 1, tab 2, to page 54, we find an obligation contained in the Electricity Directive 2009. This remains the directive that was binding at the time of the contested decision, and it's a directive, the recast directive only applies from after the IP completion date, so this is the only directive we need to worry about for present purpose. Tab 2. Tab 2, please, page 54. And please could I invite your Lordship's attention in particular to subparagraph 6 of Article 37, of which this forms part, which sets out the duties and powers of the regulatory authority. See page 52. Subparagraph 6 says, the regulatory authority shall be responsible for fixing or approving sufficiently in advance of their entry into force, at least the methodologies used to calculate or establish the terms and conditions for, and then we have A, connection and access to national networks, including transmission and distribution tariffs or their methodologies. So that is the obligation that was imposed on GEMA under the directive. It wasn't simply that they could let the contractual counterparties get on with it. They had to physically approve, or not physically, but they had to, in law, approve the methodology that was being put forward in the CUSC. And when we come on to see some of the licence conditions, that was also understandably reflected in the licence conditions, because of course GRID couldn't properly give effect to the CUSC unless and until it had been formally approved by GEMA. Now there's also a fundamental point here, which is that regulations don't actually have to be implemented into domestic law. Indeed, there is a preference for them not to be implemented into domestic law. And the reason for that is set out in a judgment of the CJEU in a case called Zerbon. Please could I invite the court to take out Bundle of Authorities 2 and turn to tab 13. The facts of the case involved a rather complicated customs procedure. The question was whether or not some domestic rules of implementation governing at which point existing contracts would be caught by a change in legislation was something for the domestic legislation or something that necessarily was set at EU level. It was in the context of a currency crisis in Italy, where there was a restatement of the value of the lira against the US dollar, and the question was whether or not steps that were taken to deal with that revaluation of the currency applied to existing contracts. If, please, we could turn to page 695 in the judgment, internal page 114, we see at paragraph 19, a series of questions were asked. Paragraph 19 sets out the first three questions under the reference were whether member states were authorised to adopt provisions having the force of law to determine the specific criteria for the applicability or otherwise of monetary compensatory amounts to existing contracts. There's then set out in paragraph 20 some of the relevant provisions of EU law, and we see at paragraph 21 that the Italian legislature had taken certain steps to give effect to that. Please could I invite the court then to read the reasoning at paragraphs 22 through to 27 as to why it was not open to domestic law to modify, conceal or impede EU law obligations. So that's please 22 through to 27.
Didn't Italy at the time have a practice of wholesale implementation of regulations through just simply repetitive copying out into Italian law?
That also did not stand in their favour, as I understand it, my lord. It wasn't even gold plating, it was simply cut and paste.
It was, yeah.
So whilst of course it's open to national legislators or indeed national public bodies to adopt guidance as to how particular terms in a regulation should be applied, what you can't do is modify or change the obligations in the ITC regulation itself, transposing that to our case. Now, for many years, there was simply no real mention of the ITC regulation in the CUSC at all. It was a thing that stood completely apart. That changed with effect from, I think, 2014. Please, the quickest way of me doing this is to take you, please, to an annex to our Statement of Facts and Grounds below, which is in Core Bundle 2, tab 23, page 522. Now, you haven't happily been burdened with all of these previous decisions. Tab 23, page 522. My Lord's bundle in bundle 2 has tab 23 in it. And please could we pick it up at page 522. Paragraph 14, this is an annex to our pleading. We say that the possibility of a breach of the threshold was first raised in GEMA's Project Transmit Technical Working Group in September 2011. Predicted the upper threshold might be exceeded. And as a result of that, GRID brought forward a modification proposal to the CUSC in CMP 224, and that stated that if in any given year the average annual generation transmission charges do not fall within this range, National Grid runs the risk of being non-compliant. Therefore, it's important that the average charges remain within the prescribed range. The driver for this is to counter the risk of non-compliance. The proposal, therefore, paragraph 50, was that effectively there should be a mechanism by which compliance could be assured. The proposal also noted a fixed rate of recovery of 27% of TNUoS charges risked putting GRID in breach of the upper threshold, given the trend of year-on-year increases in the overall TNUoS revenue. Therefore, proposed putting a cap on the annual generation so that average annual transmission charges would always stay within the range. This was the origin of the GD split of 2773, which my learned friend Ms. Smith referred to earlier. Paragraph 17, GEMA duly directed that modification be made, and that gave rise to what Ms. Smith has called the CUSC calculation, which essentially, on an ex-ante basis, sought to set a tariff for transmission charges that would be within the permitted range. That, of course, did not bake in any definition for the exclusions. It was simply saying you will apply the ITC regulation and the tariffs you set will be guided by the ITC regulation, but that's done on an ex-ante basis and we have this proxy in order to maximise it. Now, what then happened, as we see from page 525, paragraph 22, was that British Gas, I'm sorry, I've skipped a stage. The first stage at 525 was paragraph 21, was a modification to the GD split. That was proposed by Intergen, 2014. The historic split had been 2773. They suggested 1585 would give more wriggle room and reduce the risk of a breach of the upper threshold. And then what happened in August 2015 was that British Gas suggested that rather than having this rather inaccurate system of prediction up front, why not simply have an ex post reconciliation whereby you obtain details of exactly what the respective charges should be between generators and suppliers after the event. That was rejected by GEMA, and therefore they didn't adopt an ex post reconciliation process. The next stage was that in CMP 261, which was a modification that my client's SSE had proposed, one sees at paragraph 24 that SSE became increasingly concerned with effect from about March 2016 that there would be an imminent breach of the upper limit of the threshold, the regime, and therefore they proposed a mid-year tariff modification to enable a reconciliation payment in the spring of 2016, which would have avoided the need for an ex post facto assessment. That suggestion was subject initially to a send-back procedure, see page 527, paragraph 25.2, and then led to an outright rejection by GEMA on the basis that properly construing, on their case, the connection exclusion, it didn't cover generator-only spurs offshore, and therefore there was no risk of an imminent breach. Now, all of that is the archaeology. You've heard from Ms. Smith that the consequence of the CMA decision in 2018 was that there was a concern that the connection exclusion did not mirror the connection charges in the CUSC, and therefore there was an under-inclusion of under-inclusion of charges in the existing CUSC procedure, which of course fed into the ex-ante adjustment. As a result of that, National Grid advanced the CMP 317 proposal, and that had various suggested changes for the CUSC, including the implementation of a specific definition for the connection exclusion. Now, as we've also heard, the direction from Grid required two things to happen. Could we please take out that direction again? I know you've seen it, but I would like to just make two short points on it, if I may. It's in Supplemental Bundle 1, Tab 7.
Have we finished with your?
Yes, my pleading can go. Supplemental Bundle 1, Tab 7. Let's pick it up at 111, and then I'll take you to the page, if I may. So 111 is the direction that Melinda and Ms. Smith took you to. If we start at 111, what we see here is GEMA as the authority directing Grid to raise one or more code modification proposals in the terms and for the reasons set out in the annex. And they had to do so in sufficient time to enable them to be effective as from 1st of April 2021, which is the beginning of the charging year. We then see at page 112 that the reason for the direction was to essentially remove the TGR charge as a means of adjusting the relevant generation charges applied to generators. And we see in paragraph 2 to set the transmission network generation residual to 0, subject to ensuring compliance with ITC regulation. So it required to do two things. One, set TGR to 0, and two, ensure that you've complied with the ITC regulation. Now, the specific form that that direction then took is as set out by the learned judge in his judgment at page 118 of this decision, paragraph 45.
What does that mean? Set the transmission generation residual to 0, subject to ensuring ongoing compliance. I mean, you can. Well, what is set against you, as I understand it, is you can set it to 0. It just means that at the end of the day, you've got to comply with the regulation at the end of the year in terms of ensuring that the range is hit.
Yes.
So why does that latter, subject to ensuring compliance with at the end of the year, affect setting the TGR to 0?
Because what was being envisaged was that TGR was being used ex ante to come up with a figure in the light of the CUSC calculation that would enable the residual charge to match the overall projected figures. There was no provision prior to CMP 317 and 327, there was no provision at all for ex post reconciliation. That's why we had to initiate CMP 261 with our request for an ex post reconciliation through a mid-year change. And you'll recall I've just mentioned British Gas had suggested an ex post reconciliation method, but that had been rejected. So what we see at page 118 and 119 is two things. Firstly, there is a direction specifically to National Grid to bring forward under paragraph 45 a change to the methodology in section 14 of the CUSC to set TGR to 0. So that's no longer going to be used as a mechanism by which you can ensure compliance ex ante with the ITC regulation, so far as it's possible to do so. Instead, what's being suggested is, see paragraph 46, that proposals for an appropriate adjustment change to ensure compliance with the ITC regulation is put in its place. So they're saying TGR will be 0, you need to come up with a different way of doing this. And what they also said, see paragraph 45, was you should ensure that generators are charged all applicable charges, having factored in the correct interpretation of the connection exclusion. Two things, TGR will go to 0, 2, you need to come up with an adjustment mechanism, and that adjustment mechanism must reflect the correct interpretation of the connection exclusion. That's what they were directed to do. As we know, that isn't what they did.
Sorry, apologies for being slow. When you say that the adjustment mechanism must reflect, sorry, I can't remember your exact wording. You say the adjustment mechanism must reflect the connection definition.
Yes. So in paragraph, let's do this in stages if I may, I've probably gone too quickly, apologies. Paragraph 45, the last sentence says this should be achieved by charging generators all applicable charges, having factored in the correct interpretation of the connection exclusion as set out in the ITC regulation, and adjusted if needed to ensure compliance with the range. So you're going to be setting TGR to 0, see the first sentence, subject to ensuring ongoing compliance. That ensuring ongoing compliance requires you to, 1, apply the correct interpretation, and 2, adjust the figures if necessary to ensure compliance. And we then see in paragraph 46.
Okay, the way it's put against you, and I'll come back and ask the question again maybe, the way it's put against you, which I grapple with, is it doesn't actually matter what interpretation you use when you're setting the ex-ante charges, provided that when you assess whether you have met the range at the end of the year, and if necessary are going to have to make an adjustment, you do use the correct interpretation. So and I know your case is you've got to do it at both stages.
Yes.
But is your point in showing us this just because this is what Ofgem said at the time?
Well, this was a binding direction given to National Grid as to what they had to do with their modification proposal. So they had to bring forward a correct construction of the connection exclusion, and they had to put in place an appropriate adjustment mechanism. Now, what your Lordships I don't think have seen yet is the amendments that accompanied the proposals that were made, which included not only a modification to the ex-ante calculation, but also an ex-post reconciliation within the CUSC. And I'm going to come to that.
Why does it matter? Underlying this is a fairly fundamental point of principle as to whether compliance needs to be made, as the judge found, or whether it can be done in stages, involving adjustments and reconciliations after the event to bring it back into compliance. And we've seen the history, but you've got to persuade us on the construction of the ITC regulation that there's something which prohibits or prevents that longer term decision-making process. What is it in the regulation itself which prevents that?
Well, my Lord,
I mean, isn't that really at the base? Is it just a short point of construction? There's a lot of history behind this, I understand that.
my Lord, no. It's an error of law to give effect to the ITC regulation by putting in place an erroneous legal construction of a legal term.
Well, wait a minute, to give effect in what? Obviously, if at the end of the year you are saying, have you hit the range, and you apply an incorrect interpretation, obviously
But that's what
not right.
That's what they've done.
But if
Because
you
they've
are
hardwired the same definition into the ex-post reconciliation process as the ex-ante one. And in my submission, it
there
matters
is
not.
no ex-ante reconciliation process.
There is no ex-ante reconciliation process. What you have is the ex-ante setting of tariffs, which are designed to minimise the risk of a breach.
Right, but if there were going to be a breach, if you can see, oh, well, actually, there is going to be a breach, that's when your ex-post adjustment comes in.
Well, both of those calculations are done to minimise the risk of breach. The second of those ensures there's no breach. I accept that.
But if the first is just designed to minimise the risk, then in a sense you don't have to use, the argument against you is, you don't have to use the correct interpretation or indeed anything else.
You don't have to use the CUSC full stop, my lord. The point is, having chosen to do so, and having chosen to, contrary to the guidance in Zabone, having chosen to put in place in a domestic legal provision a construction of the ITC regulation which is simply wrong, that is an error of law. And it's a separate question as to what the consequences of that error of law are.
Well, what's the,
And your lordship seems to be putting to me, well, it's fine that you could have gobbledygook in the CUSC, so long as somebody at some point is making sure that the range is not breached.
It's always going to be subject to a public law. I mean, if it's utterly irrational, fine, but I don't think anyone said to the judge that it was irrational. Indeed, he found that the NG proposal was better than anything else, so it was a good step on the way, if nothing else, even if in his view it was illegal.
But he found that the binding effect of the decision that was taken was to approve in a binding legal code that imposes regulatory obligations on the licensee and others, that an error of law was baked into that code. And for
But subject to, I mean, we understand that, and to that limited extent, you're correct. But that's why this all turns on timescale.
It's always subject to the fact that it was meant to be a stopgap,
Yeah.
and the express understanding that at the end of the year, matters will be sorted out so that there was
my
compliance.
lord, can I just
Necessarily
deal with
at the
that
end of the year,
stopgap
but over a
point?
longer period of time, because I doubt this was going to be sorted out within 12 months. But there's nothing which says it has to be done at the end of the averaging year, or maybe there is, but
There is.
well, it depends on the definition, but there's going to be an ex post reconciliation at some stage. All right, maybe you, isn't there? That's what it says in the decision.
Well, my lord, what it requires is that the charging arrangements that are put in place domestically must ensure that a calculation takes place. That calculation takes place on the correct basis, which is the correct constituent elements of that calculation go into the mix. And whenever that calculation is performed, you put the right constituent elements in. Otherwise, you have a flawed and legally incorrect calculation.
So given where they were, given that they had 84 non-compliant proposals put to them, which might suggest something about, well, might suggest all sorts of things, what were they meant to do? What should they do in order to comply, if not to accept a temporary interim solution?
My lord, they didn't have any system in place previously which carried out an ex post reconciliation process. So the simple point is they could have left well alone, said a plague on all your houses, none of this is right, and go back to the drawing board and come up with a better solution.
So leave the status quo with, as Ms. Smith put it, the risk of crashing through the floor for a number of years until a better solution came up.
But my lord, as I'll show you, what they've decided to do, rather than having an ex post reconciliation whereby generators have to pay back money at the reconciliation stage, they've simply sidestepped that by saying, well, we're going to change the focus. We're going to basically ensure that generators are paying too much now, and we'll rectify it in due course, which isn't, by the way, a legally binding commitment. It's simply an expectation that it will be done. And we know for a fact it wasn't done until after our successful judicial review. So can I just deal with the stopgap point? There is no stopgap. What was approved were modifications to the CUSC, which took effect immediately once they were approved, and which thereafter applied without any sunset clause unless and until a separate modification took place. And so it's very important to appreciate that the effect of the approval of the proposal was to change the charging methodology that, as I've indicated, Article 37(6) of the Electricity Directive required GEMA to approve and establish. So there's a binding legal obligation to put in place a charging methodology, a tariff methodology that was correct as a matter of EU law. And there was never any suggestion in the actual amendments made to the CUSC.
sorry, where do you get the, which was correct as a matter of EU law, bit from?
Well, my lord, because it's accepted on all fronts that the definition of the connection exclusion has in fact been hardwired into the CUSC as a code, as a charging methodology approved by GEMA, is wrong in law.
Yeah, but it's not a breach of the European Directive Regulation or anything else. You've just used a wrong legal definition.
Well, my lord, that is a breach of the regulation because the requirement under the Itc Regulation is that certain charges shall be excluded.
But only in deciding at the end of the year whether you've hit the range or not.
My lord, Itc Regulation doesn't tell you how you go about ensuring compliance. It simply says you must exclude certain charges from the calculation. You can do the calculation ex ante, you can do the
Calculation is an annual calculation, which would be very difficult to do at the beginning of the year.
That is because following the CMP 317 and 327 approval, the CUSC now included an ex post modification. It may be easier if I just show you what the specific
Stop interrupting, yeah.
amendments were to the CUSC, so you can see how it played out. And I can show you what was before, what was after,
Yeah.
and then you have my basic submission. The ITC regulation is directly applicable. You don't have to apply it at all. If you do apply it, you've got to get it right, and they didn't get it right. It really is that straightforward in terms of my submission.
So you don't have to apply it at all. Does you mean they could have just done nothing instead of plague on all your houses?
They could have done nothing at all, as in fact they did in another case, and I'll show you that in a
No,
minute.
I know you set that out fully. Very naughty of them, but here we are, different situation. What about the obligation in the regulation and the directive to secure compliance? So if they know it's non-compliant after the 2018 CMA decision, and they continue to do nothing into 2020, 2021, with a situation which is worse than their proposal, is that not in and of itself a breach of the regulation?
Well, it's hardly facilitating compliance, is it?
Well, my lord, it wasn't non-compliant beforehand, because of course there was no definition of the connection exclusion in the CUSC. There was an ex
You
ante.
say it's directly applicable.
Well,
I mean, it applies to everybody, whether it's in the CUSC or not.
but there was no breach of the ITC regulation, because of course the only problem with the position prior to, or let's take 2018 as the cut-off. The only problem in 2018 was that National Grid was seemingly conducting a calculation which was based on the CUSC terms, but there was nothing in the CUSC that required that. And I think it is important to see the terms that you can see before and after. This is in Supplemental Bundle 1, tab 12. So here we have Statement of Use of System Charging Methodology, Section 1, paragraphs 14.4 onwards. So it's a charging methodology. If we turn please to page 197, unhelpfully struck through is the system of ex ante CUSC calculation before the CMP 317327 approval. So we have here the split, starting at Roman 4 with the strike through. The application of a TNOS revenue split between generation and demand, where the proportion of total revenue paid by generation for the purposes of tariff setting for a charging year is X times the total revenue, where X is. And then we have, whilst the ITC regulation paragraph 3 is in effect, there is then a formula. And so what they are seeking to do is encapsulate within the CUSC an ex ante assessment of whether or not the MAR, the allowed revenue, will be giving rise to transmission charges which are compatible with the range limit, the upper range limit set by the ITC regulation, hence the reference to cap. So what that does, nowhere in that particular paragraph do you find an erroneous definition of connection exclusion. What you see is a method of working out from charges likely to be imposed, whether or not they will be compliant, and a necessary adjustment then taking place on the GD split. Nowhere in that existing calculation does it delve into the detail of which particular costs or charges should go into the pot in the numerator for the calculation. The only thing that we can guarantee at this stage is that the denominator for the calculation, resting as it does on energy injected into the system, is indeed there. And there's then an error margin. That forecast TO maximum allowed revenue for charging year doesn't actually tell you anything other than the amount of money that the grid operator is being allowed to recover. So that involves no legal error. What was going on in the background was that National Grid was performing a calculation on an ad hoc basis with no visibility to CUSC users as to whether or not there was a compliance. And it's that ad hoc system of monitoring by National Grid that GEMA has always relied upon when saying, don't worry, there's nothing to see here, we are compliant. And it was because of arguments between, for example, Grid and SSE as to what should go into the connection exclusion that CMP 261 was introduced, and the CMA then gave its legal decision that generator-only spurs were within the scope of the connection exclusion, notwithstanding their treatment in the CUSC. So the calculation that the ITC regulation required was not at any stage hardwired in. It was a thing standing apart. There was an ex-ante assessment which was designed to minimise the risk of breach. But the ex-post reconciliation, we don't know how, when, who performed that calculation. That's not something we ever knew. And of course that was necessarily an unsatisfactory state of affairs, because users don't know on what basis grid is making the calculations. And when there's a old-fashioned dust-up between the CUSC user parties as to what the proper basis for the connection exclusion is, that comes to light. Now, the response from grid through 327 and 317 was to propose amendments to the CUSC, which we see at page 195 to 196. And we could pick it up, please, at Roman 5. The company as grid will set tariffs in a manner so that location varying, etc. Any remaining transmission owner revenues will be recovered from demand only in a non-locational manner through a residual charge. So just pausing there, we've seen GEMA has directed TGR, the transmission generation residuals, to be set to 0, because they need to recover the revenue for the transmission network that they are operating. They have to get the money from somewhere. So the answer is there will now be a residual charge imposed on demand, which is suppliers, not on generators. And of course there's a logic to that, because any charge that gets imposed on a generator will, as a matter of economic theory, if not commercial reality, get flushed through at some point to the consumer, because the consumer is ultimately paying the price for the production of electricity, which is with respect to how it should be, because they are getting the electricity supplied. Under Roman 6, for the purpose of compliance with the limiting regulation, in the context of setting limits on the annual charges paid by generation, the company will exclude charges for fiscal assets required for connection when calculating the total amount to be recovered from generators. Now, just pausing there, could you please then turn up page 243 behind tab 13? These are the definitions that accompanied this proposal as part of the legal text that was advanced in CMP 339, which was the companion piece. So you've got the mechanics in tab 12 and the definitions in tab 13. One of the definitions is limiting regulation, which we're calling the ITC regulation. You've then got adjustment revenue, adjustment tariff, ex post reconciliation, which is the charge or credit to demand and generator users in respect of TNEOS charges in the event of a breach. So that's a new facet. And then charges for physical assets required includes all local substations and all local circuits. And it's that definition which is too broad, as GEMA's decision has acknowledged. I haven't yet been through GEMA's decision because I segued into this particular document in order to answer the bench's questions. But that definition is too broad. That definition is the definition that gets plugged into, going back to page 195, ensuring compliance with the ITC regulation. So the CUSC, reflecting the ITC regulation, now says you have to exclude these charges. Those charges are defined too broadly. What that means is too many charges will be excluded from the calculation. And other things being equal, because that reduces the value of the numerator in the calculation, the overall level of permissible kilowatt hours in euros will, all other things being equal, be lower than if you had more in that pot. And the result of that is you will find that there's a suppression or a decrease in the overall tariff setting, because the point at which the limit bites on the cap will be lower than it otherwise would be. And that, in a nutshell, is what Mr. Justice Swift was alluding to when he talks about generators paying less in paragraph 40.
But there's no European requirement in relation to what a particular generator pays by own tariff.
No, there wasn't a harmonisation of the underlying methodology.
So, I mean, by definition, it can't be sort of. I'm struggling to understand what the unlawful nature of getting the tariff calculation wrong is.
My Lord, the result of putting an erroneous legal definition into a statutory calculation is that the statutory calculation is vitiated by that error of law. And I'll take your Lordship, if I may, in due course to a decision of Mr. Lord Justice Buxton that says exactly that in a planning context. So
That's a matter of what English common law, is it? That if you put a statutory definition that's wrong into some domestic legislation.
well, Lord Diplock in GCHQ said a public authority has to get the law right in the sense of both ascertaining the correct meaning of the statutory term that's being applied and then applying it.
And how does that sit alongside the objectives under the CUSC?
The CUSC is a contractual overlay supported by licensing requirements. It's not actually the directly applicable legislation. The directly applicable legislation here is the Itc Regulation, and you have to get those terms right. If you don't get them right, it's an error of law. And as from the cases I'll show you in a moment, the courts have consistently said if there's an error of law, it has to be corrected. The courts step in. The court's the final arbiter of what a correct lawful construction is of a piece of legislation. And if a public authority gets it wrong, the courts step in. I'm hoping that's not anything other than Constitutional 101, but I will take this court to cases that support that. If it's a question then of does EU law make any difference? No. If anything, EU law imperative is even stronger from the Zerboni case that I took the court to. You cannot modify or alter the EU law obligations. And the obligation here is shall. You shall exclude these connection charges from the calculation, but it does mean you need to get the definition of the connection exclusion correct, and it's physical charges. Physical charges required for charges for physical assets required for connection. Now, true it is applying that particular term to a given set of facts may be difficult, but that particular definition has only one construction, and it's a correct construction or it's an incorrect construction. And GEMA has accepted that what they have included by approving CMP 339 is an incorrect construction. Can I please go back to page 195 and I'll show you how this comes out. So if having applied the exclusion of charges for physical assets required for connection, the company identifies that an adjustment is required to remain compliant with the limiting regulation, then an adjustment tariff will be applied to all generators in the following circumstances. And this is largely an ex ante consideration. So they're looking at forecast charges, they're looking at what the expected charge will be, and then they're having an adjustment to it. And we see that there's a countervailing adjustment for demand users. And we see various formulae used for dealing with the adjustment with an error margin and so on. And that's either a negative tariff, see page 196, or it's a positive tariff that will be applied, which will increase annual average TNOS charges to generators as a class. But there's a specific mechanism in the CUSC by which an adjustment mechanism then takes place. Now the next stage is to look at page 201, please. And there's an insertion there which reflects the adequate recovery and effectively the residual tariff being imposed upon demand only. So there's never going to be a shortfall for grid, it will get its money come what may, but the residual recovery is going to be via demand or suppliers. If we could then please look at page 212. What one sees at the bottom of page 212 is a provision that previously said reconciliation of demand charges, but now says reconciliation of demand charges and TNOS charges in the event of exceeding the limits to generator charges in the limiting regulation. And 14.17.23 says the reconciliation process is set out in the CUSC The demand reconciliation process compares the monthly charges paid by users against actual outturn due to settlements. Reconciliation of demand charges is carried out in 2 stages: initial reconciliation and final reconciliation. And that's demand. There's a comparative provision for generation that I'll come on to in a moment. The next paragraph then says, in the event of annual average transmission charges incurred by generator users in the charging year not being in compliance with the upper or lower limits, an ex post reconciliation adjustment will be applied to both generator and demand users to bring charges back into compliance. Now, we've seen that there's a reference to the reconciliation process set out in the CUSC. What the court doesn't have is section 3 of the CUSC that contains the general reconciliation process. Now, if I may, I'll produce a copy of this tomorrow morning first thing. But having looked at it over the shorter German, bearing in mind that the timing point wasn't at the forefront of Muller and Friends' submissions in their skeleton argument. Section 3.13 of the CUSC effectively requires a revised set of generation charges to be imposed on generators by 30 days after the close of the charging window. Now, the close of the charging window is the 1st of April. Therefore, what GRID does is it sends a generator reconciliation statement to generators saying we've looked at actual outturn for the year, and bearing in mind that their generation may have been higher or lower than they had predicted. There may be manifest error built into what they've done. And so a reconciliation statement is sent within 30 days of the end of the charging year, just under the CUSC section 3. That then has to be paid within 30 days thereafter. And my client therefore has to pay the invoice when it's submitted within 30 days. There's then a separate reconciliation process for demand once they've worked out who's paid what. So there are time limits. Those time limits are in the CUSC. And essentially what's happened here is this reconciliation process has been bolted onto an existing reconciliation process dealing with generation charging. Could we please then look at page 214? And this is a detailed set of provisions dealing with what happens if the limits set by the ITC regulation are exceeded. And we see 14.17.36, the company shall, that's GRID shall, following the completion of each charging year, produce a statement setting out the annual average transmission charges paid in aggregate. In the event that the annual average transmission charges attributable to generators exceeds the upper limit, then the next post reconciliation will be calculated for generator and demand users as per the below. What you then see, and this is a calculation that was approved by GEMA and which hasn't changed, and which the order of Mr. Justice Swift has not set aside, we then see a detailed reconciliation process where specific adjustments are made to the charges, and each of those specific adjustments can then be applied on a generator by generator basis. And that's featured in the updated invoice that will then be sent by GRID to my clients by the end of April in every charging year. So when Ms. Smith was saying she didn't know how you would go about setting an ex post reconciliation process for charges, the answer is it's there, it's in the CUSC, and it was approved by GEMA. Now, those charges, true, they are set on an aggregate basis for generators as a class, but of course the actual bill that comes through to a generator is a calculation based on those aggregate charges to the level of energy that my particular client has injected to the grid at a given point or at multiple points. And so you get the overall structure of the calculation, you times it by what's called the TEC, the energy injected into the grid, and that produces a figure. And there's a detailed arrangement whereby you can adjust it, and you adjust it for ensuring compliance with the ITC regulation. But it's therefore crucially important that the ITC regulation is applied in the correct manner. Because as I've said repeatedly, rubbish in, rubbish out. If you've got an incorrect component for the calculation, then this ex post reconciliation will be flawed as a matter of law.
Well, of course of course it will, but that doesn't answer the question that we've got in the case in front of us.
Well, my lord, it does, because if I may say so, I've given two reasons why it matters that the right term, legal term, is included in the CUSC if you are going to build the ITC regulation into the CUSC.
Well, if you're going to,
But they have.
they've done that by.
If you're going to build the incorrect interpretation to the ex post, sorry, to the question of whether at the end of the year you have not complied with the regulation, then obviously it falls apart. You're not applying the test in the regulation. You just aren't, because it's done at the end of the year.
Well, my lord, that's what this does. This ex post reconciliation process requires amendments to be made to ensure compliance with the limiting regulation. That requires you to apply the calculation that is set by the Itc Regulation, but which is necessarily determined by the definition of the connection exclusion set out in the CUSC. Because otherwise, you have a disconnect between the definition of connection exclusion, definition of the connection exclusion at CMP 339, and the actual almost platonic conception of what the correct definition is that is latent
Maybe
behind.
I'm just still catching up and everybody's way ahead of me, in which case I apologise, but is this the basis on which Mr Justice Swift decided the case? These provisions?
I took Mr Justice Swift, it was one of the first things I did, because he said almost from the get-go that this was a very straightforward case which involved the question of construction of both a regulation and a corresponding contractual framework. And so having taken him to the Itc regulation, I then went almost immediately to the amendments to show how things had changed and how the Itc regulation was now being implemented in a way that was unlawful. And the reason it's unlawful is because GEMA has chosen to include ex ante and ex post calculations to ensure compliance with an Itc regulation.
So you say the critical ones, it's not the ex ante one that we've been focusing on this morning. You say no. It's just doing the ex post calculation that's required by the regulation will be done incorrectly because they're using the wrong definition.
My lord, it's both. But if you're asking me which is the one that has more practical significance, the answer is the second, because you're always capable of dealing with any ex ante infelicity by an ex post reconciliation process. I recognise that. But both of them should have the correct definition, correct legal definition put in, because otherwise there's an error of law.
So if a new proposal comes forward and the ex post reconciliation process is amended and it's backwardly applied, then we say that's irrelevant. I mean, that's the issue, isn't it? I mean, in a sense, we can accept that where you get to, but you then bring the shutters down. And GEMA says, well, that's not the end of the story. I mean, one of the things that puzzles me here is why 84 companies got the calculation wrong, unless they're gaming the system.
My lord, I don't think there's ever been a suggestion my client was gaming the system. The reality is that
What about the other 83 then?
The other 82.
Other 82. I mean, everybody's trying, we understand it. Everyone's going to try and make their submissions in order to get the best financial advantage out of it. There's nothing wrong with that. But 84 companies getting it wrong and then placing the regulator in this position of having to go back through this somewhat convoluted modification process puts them in a pretty difficult situation.
My lord, it's not 84 companies, it was 84 proposals.
84
So some
proposals.
companies made multiple
Okay.
proposals.
Well,
Putting that to one side,
there's an enthusiasm for something which isn't correct, doesn't it?
I mean, they had the 2018 CMA decision. It wasn't as if there was no guidance. They weren't starting from a blank sheet. They knew what the target was. 84 proposals were wrong. There's something there.
the CMA decision that lies behind the CMP 261 decision adopted a definition of the connection exclusion which was at odds with the definition adopted in CMP 224. In 224 they adopted a narrow definition of the connection boundary, and in CMP 261, for better or worse,
GEMA sought to apply it. I mean, the review which followed was partly to implement, right or wrong, the CMA decision of 2018.
in part.
So everybody knew what they were aiming at when they put in their modification proposals.
There were very strongly held views as to
Sure.
once you've got GOS, offshore GOS, as the basic unit of TNOS charging which needs to be added into the connection charges pot, was there anything more? And the key issue was there a bright line test whereby you could work out whether or not a particular asset was required for connection? Answer, difficult. And Mr Justice Swift, I think, suggested that trying to give any more flavour to what that term means was perilous. But nonetheless, that's what GEMA did. Having done that, having tried to give the non-binding guidance through a domestic code, which Zabon says be very careful and make sure you get right, they got it wrong. And as a matter of binding CJ your binding CJEU authority wrongly implementing a regulation is an error of EU law.
Depends upon, we're all begging the question about what the regulation means.
Well,
And, you know, whether you can go through one stage to get it right or two stages. I mean, that all depends on what the regulation says. And it's silent as to all these things. So you've got to stand back and construe it purposively.
well, my lord, I have no intention to ask the bench a question, but
Feel free.
may I simply say, asking perhaps a leading question for the benefit of my
Pretend it's
case.
rhetorical.
Rhetorical leading question.
Yeah.
Yes, a rhetorical leading question, they're the best sort. Where is the second stage calculation? There is none.
There isn't one, but there's a process which will lead to it. You're right. I mean, it hasn't happened. Well, we haven't seen the evidence as to what happened after, after the stopgap.
My lord, if it were the case that a public authority decision could be justified on the basis that, well, we've got it wrong, but we may get it right in due course, and we hope we will.
We understand that principle, but that's not the point. See, the issue is as to the status of what they were doing along the way, and whether, if at the end of the day what they end up with is compliant, as they anticipated it would be, because that's what they told National Grid they had to do. Then your case is that notwithstanding, let's just assume that they did, whether it's already happened or because we don't have the evidence, or whether it happens next week or next month or whatever, then they actually produce a result which is totally compliant. On your case, that makes no difference because along the way, there's been a breach of the regulation, therefore that was unlawful and the whole thing should have been unravelled. So that you'd have ended up with a situation which was far worse, as the judge himself recognised, than the original proposal.
My lord, it wouldn't have been far worse if one assumes the premise for my learned friend's argument, which is there's always going to be an ex post reconciliation process, it's just you can't see it. Now, if that's right, then the vice that was vitiating the ex ante approach prior to these amendments would have been cured, because my clients would have faced
What are you objecting to? I mean, I'm still trying to get my head around where the commercial incentives lie in all of this. Your posited counterfactual is he leaves the situation as it was, and then there's an even bigger gap to reconcile in whatever period of time. And they might rationally take the view that it's better to have a smaller gap to reconcile rather than a bigger one, less disruptive, possibly better signalling for future investment decisions, so on and so forth. But what's wrong with that? I mean, your situation is the same as their adopted situation. You've got a period of illegality leading to reconciliation. So what's the difference? Why is one illegal and the other not?
If I may say so, I suspect your lordship's approach is conditioned on viewing this as an outcome-driven requirement rather than a process-driven requirement. There is a process that is required, that is mandated, and is a mandatory requirement, which is the calculation has to exclude certain charges from the pot. If the calculation that's adopted is wrong in law, then that is an error in law. And the outcome will be that the calculation is vitiated by that error of law. And if I'm wrong on that, then essentially the entire decision of Mr. Justice Swift has proceeded on the wrong basis. Because you would be finding that actually properly construed, nothing in points 1 to 3 of the ITC regulation mandated a calculation with specified criteria. Because you would say, well, it's fine, you can do whatever you like in the calculation, so long as at some point a hypothetical regulator does a double check and make sure the range is complied with. And that was Ms. Smith's argument.
At the end of the day,
At the end of the day.
there's compliance at the end of the day.
But my lord, where is the compliance at the moment? Because, and that is again a rhetorical
But
question.
you're not suggesting you can get immediate compliance. I mean, you accept there's going to be a time gap before everything can be brought into place.
Well, my lord, the counterpoint to that is we have immediate non-compliance.
Yeah.
And that continues pro tem until there is a modification.
Yes.
If that
But
is
you
accepted,
accept that it will take time.
well,
I mean, you set out very, persuasively in your skeleton all the different ways in which they can seek to come into compliance. Some of them relatively quick, you say, but in none of them do you say it can be done overnight.
Well,
There's always a process which has to be gone through.
the position they adopted was to take a state of affairs where there was ex hypothesi compliance with the Itc regulation, because nothing in the CUSC said anything about the connection exclusion. And so they could merrily do the calculation in conjunction with grid and make sure that they were satisfied. They then choose to change that state of affairs and introduce a legal error. As I say, if I'm wrong that a legal error is caused by the defining of a term that's wrong in law, then again I can pack up my bags and go home. But I'm hoping to persuade your lordships in due course that if, as a public authority, you wrongly apply a legal term, then that is an error of law.
At the risk of worrying away like a dog with a bone at that, and because you went very fast, and I'm afraid this with a very slow brain is just catching up.
My lord, no, I'm sorry.
Can we just go through what you said a little while ago in relation to the changes that were made to the CUSC? And you took us to page 195
Yes.
in tab 12. These are the changes to the tariffs, yeah, that were introduced.
Well, what we see in sub-Roman 6.
6, correct, okay. So that's where I was going to take you, and it's the definition of charges of physical assets required for connection.
Yes.
And if you go to page 243, there's the erroneous
Yes.
use of the definition. Got that. And Mr. Justice Swift, in his judgment, if you've got that to hand,
Will do.
he picked this up, as I understand it, at paragraph 28, where he refers to those relevant bits. And when he comes through then to deal with his decision, at paragraphs, say, 37
Yes.
and on, when he deals with the modifications that are made to the CUSC and the incorporation of the incorrect definition, he is dealing with that we've just been looking at.
Yes.
Yes. The answer to all that, according to your opponents, is that's looking at the wrong bit, because that's dealing with the charging tariffs. You can always correct it at the end of the year in a way that is regulation compliant.
Well, there was no mechanism prior to these amendments by which there was no mechanism in the CUSC by which that took place.
But there is now a mechanism in the CUSC.
So that mechanism in the CUSC is based on the incorrect calculation.
Well,
No, wait a minute.
No.
So that's where I was going to take you. So that you then this is where I was just desperately trying to play catch up. You then put us to the ex post reconciliation section, which is 1417, etc.,
Yes.
which talks about the ex post reconciliation section. Yeah.
Yes.
And where does it use the incorrect definition in any of that?
Well, that comes from the one we've just been looking at, which is for the purposes of compliance at page 195. In the context of setting limits on the annual charges paid by generation, the company will exclude. So the company has to exclude it not simply at that stage, but also from the ex post reconciliation,
So you're saying that
because it's dealing with compliance. Ex ante, ex post is simply a point at which
This is CMP 2172, sorry, 317327.
yes,
Then the definition is in CMP 339,
yes, because they were part and parcel of
which
the
is
same.
all on the same day in
It was approved at the same
2020.
time. I understand it to be common ground that they are a package,
But
and you couldn't have one
But
without the
then what the GEMA decision then says is, well, this is not, as it were, fully compliant, but it's a stopgap, and you, National Grid, must go away and come up with something that is compliant. So that what's then being postulated is that there will then be an amendment to all of this at some stage in the future, and they will come back and they will say, well, we're now proposing this amendment, which will make it fully compliant with the regulation.
My lord, the 339 can be severed from 327 because that's what the judge's order has done. The judge's order has basically put a red line through that definition and said everything else can stay. And as you've seen from my submission, that would remove the illegality. But the point is, at the moment, up until the judge's ruling, that was the outcome. The outcome was that that wrong, unlawful definition was necessarily...
Let's assume that there was, National Grid did come up with a proposal, a further proposal, which was otherwise compliant. Then it would follow, wouldn't it, that whatever legality there was at this stage would fall away.
Well, my lord, in answer to that question, of course, as soon as a public authority is directed, as it was here by the court, to do something about it, and has done something about it, probably your lordship needs to see what GEMA has done, because I don't think you were taken to that. If one could turn, please, to...
I'm sorry, I'm the second dog with a bone here. As a matter of principle, this all turns upon what we are to deduce from the Itc regulation. Does it permit, if you like, interim pro tem positions which may not be fully compliant? If you're right and you can't construe it as permitting that, then you win. But there's nothing in there which talks about methods of compliance. It's really a very broad framework. It sets out parameters. So it doesn't say anything about what under that law the regulator must do in order to comply. So the regulator here says there's no time limits, save for what you might deduce from the definition of an annual average charge for producers. And then therefore we are going to take our time, in accordance with the mess that the state of the industry is in terms of pricing, to get to a position of compliance. So we therefore have to deduce from somewhere that that's unlawful. Now, we understand your position, we absolutely understand it, but the question is whether you bring the shutters down too quickly. And what is it in the law, what are we meant to look at, which helps us find the answer to at what point you bring the shutters down? Are they viewing this purposively, we viewing it purposely, going to allow them to say it has to be done in stages, recognising that it's almost impossible to do these things overnight. Whatever powers they have may be inadequate. Even if they had a power of freestanding power of initiative, they'd still have to consult. It's going to take time. So you hold the ring with the best solution you can come up with until such time as you could. We've got to just find something in the legislation, not really in the administrative history. That might just proceed on a comedy of errors, year in, year out. We've got to find something in the legislation which helps us determine this. What is it in the law which says they can't do it? Well, really it's for you, isn't it? I mean, if they've got a discretion, well, they're very broad discretion, where is it that says they can't do it?
They don't have a discretion, my lord, to get the law wrong.
Okay, well, tell us what prevents that discretion.
Well, my lord, the common law and the CJEU authority. Could I turn perhaps to the Lewisham case, which is in bundle of authorities?
Do I deduce that you don't say there's anything in the legislation, the EU legislation or the EU retained legislation?
No, my lord, because your lordship's asking me a question which simply does not arise on the facts of this case. Your lordship's putting to me, is there anything in the ITC regulation that stipulates how the means of compliance should be dealt with by a domestic authority? The answer to that question is no. But conversely, is there anything that in law permits a national regulatory authority, when giving effect to EU law, to get the EU law wrong? To which my answer is no.
That begs the question of what the EU law says.
Well, that's why I'm saying, as a matter of law, they had to get the right definitions into the calculation. Otherwise, that was an error of law.
Well, they say they will, it just takes longer and it's a more convoluted staged calculation. That's the issue, isn't it? What helps us determine that point? If you're right and they can't do that, then nothing is going to save them. Common law is going to jump on them like a ton of bricks, etc., etc.
Well, my lord, the simple point is, I think, that a definition...
Nothing simple here.
A definition of law has only one meaning, and here it's been acknowledged that definition is wrong. Could we start, please, with tab 21 of the bundle of authorities? I won't go to Lewisham, I'll start from the beginning, because it may well be that I've simply misunderstood what the legal requirements are to get the law right, and if so, that's a complete answer to this whole case.
What's meant by getting the law right? What is the law?
Well,
what is it that the right thing that they have to do?
Could we look at the MMC case, decision of Lord Mustall? And I'm sure the court's very familiar with the facts behind the South Yorkshire transport case. It depended on whether or not the relevant merger of transport companies in Yorkshire reflected a substantial part of the United Kingdom. If we could turn please to page 1035 behind tab 21, Bundle of Authorities 2. His Lordship at the top of the page from A to B dealt with the statutory construction of what a substantial part of the United Kingdom was intended to refer to. And we pick it up please at subparagraph D. On the second question, the parties are at odds as to the proper function of the courts. The respondents say that the two stages of the Commission's inquiry involved wholly different tasks. Once the Commission reached the stage of deciding on public interest in remedies, it was exercising a broad judgment whose outcome could be overturned only on the ground of proportionality. The question of jurisdiction, by contrast, is a hard-edged question. There is no room for legitimate disagreement. Either the Commission had jurisdiction or it had not. The fact that it is quite hard to discover the meaning of section 64(3) makes no difference. It does have a correct meaning, and one meaning alone. And once this is ascertained, a correct application of it to the facts of the case will always yield the same answer. If the Commission has reached a different answer, it is wrong and the court can and must intervene. Now, His Lordship then agreed with this argument in part, but only in part, and he said once the criteria for a judgment has been properly understood, the fact that it was formally part of a range of possible criteria from which it was difficult to choose and on which opinions might legitimately differ becomes a matter of history. The judgment now proceeds unequivocally on the basis of the criteria as ascertained. Now here, the connection exclusion is a term of law. It's a term of European law. It has only one meaning. True, that meaning has to be applied to given facts in given permutations, but it has one meaning. And as we know from the GEMA decision, it's been accepted throughout that the meaning that was approved under CMP 339 was wrong in law. And that doesn't go into the question of, well, how could they go about sorting it out? Because going about sorting it out is simply a necessary consequence of making a legal error. And if the position were that it was always open to a public authority to say, well, we knew it was a bit dodgy, we've been found out to be wrong, please give us latitude to be able to come up with a better definition, you would never ever have an illegality.
Would you, if the judge had said there is illegality, but given the mess that this is in, I'm going to make no ruling save a declaration, I won't quash the decision, and I will endorse as relief the process which has been proposed.
And that was a submission that my learned friend Miss Rogers made to the learned judge below.
But that wouldn't be acceptable in your view.
Well, it's not what the judge did.
Wouldn't it be acceptable?
And there hasn't, well,
Now you're squirming, I'm going to ask you, would it be acceptable?
I'm not squirming, my lord. What I'm seeking to do is defend the judge's decision.
Oh, don't do that.
Well, that's quite a sensible place to start.
If the judge got the wrong relief, then
Well,
that would be a reason.
but that isn't one of the grounds for appeal.
But it rather puts this thing into context. It would have created no difference whatsoever. He'd have said, all right, technically, you're right, but frankly, in terms of relief, you know, am I going to resurrect a situation which is far worse when actually you're making solid, sensible efforts to get it right?
What this shows, my lord, with the greatest respect, is that this court has come up with another reason why a ground of appeal should have been articulated and put to me. And I don't mind that because I've been before this court many times and it happens quite a lot. But the reality is I need to call a spade, and this is not an argument I've faced. It has not been suggested that the judge erred by giving the relief he gave.
But all right.
Hypothetically, was he wrong to give the relief he gave? With respect, no, because it does affect the charging years that have gone to date. And therefore, what you can't do retrospectively is cure the charging years that have gone to date unless you have an ex post reconciliation method, not just for the charging year just gone, but for the charging years previously. And that's what the CUSC does not do, and the bits that are left in the CUSC don't do, because as I've shown you, lordships, the ex post reconciliation process ties back into section 3, and that's for the last charging year only.
We understand that. I mean, and in a sense, one can't speculate as to what the remedy might be. But if there's a duty to remedy the breach and it goes back 2, 3, 4 years, then so be it. That's what European law and retained EU law would require.
But if that's the case, my lord, there's nothing at all wrong with having declaratory relief that says you have committed an error of law and therefore your decision is unlawful. Now, what the consequences of that are for GEMA, well, we can see what they've done, because following Mr. Justice Swift's decision, I appreciate I'm leaping around going from authority, but I did want to just show you, I think I was taken off on a slight tangent on something else, but if we could look please in Supplemental Bundle 2, tab 27, page 463. So that's Supplemental Bundle 2, tab 27, page 463. This is part of the decision on CMP 368. So CMP 368 had been held in abeyance pending the judicial review, and it had a series of proposals designed to flesh out exactly what was meant by the connection exclusion. At page 465, second paragraph down, we see GEMA recording the fact that unless and until the Court of Appeal overturns Mr. Justice Swift's judgment, they have to proceed on the basis that states the law. And then at page 468, we see that GEMA rejected all of the proposals. And they rejected CMP 369. They rejected none of the, all of the proposals because it said none could lawfully be approved in the light of Mr. Justice Swift's judgment.
Sorry, where's that, Mr.?
That's at the top of page 469. First reason. None of the proposals could lawfully be approved in the light of the judgment, therefore they've rejected them all. And then at page 477, second paragraph. As we have been unable to approve any proposal under CMP 368, we have today used the powers afforded to us under CUSC 8.17a.1 to bring forward a CUSC modification proposal and directed the panel as the appropriate timeline for it. Now, the appropriate timeline, I think, was a matter of days, and 9 days or so. But could I also then draw to your attention the power that was used, which can be seen behind tab 25, page 454. Ms. Harman's correctly identified 8.17.1 as the CUSC provision relied upon. And that says the authority may itself or direct the company to raise a CUSC modification proposal where the authority reasonably considers that such modification proposal is necessary to comply with or implement either the electricity regulation and or any relevant legally binding decisions of the European Commission. So that is the power that's being relied upon. GEMA are curing the defect, which was a breach of EU law, by modifying the CUSC. And what they did, as Ms. Smith indicated, was simply they struck through that section of 339 and inserted instead into the CUSC the bare words of the definition of the connection exclusion found in the Part B guidelines themselves. So they have done what the Italians used to do, which is simply cut and paste the regulation into a domestic measure in order to ensure compliance.
Under 1817A.1, they can't compel the company to come up with a proposal that they like.
No, that is GEMA directing the company to bring forward the proposal. The proposal will have been drafted by GEMA, as it was. The company then has to go through the work group procedure, but in this case, GEMA set the timetable, so it's incredibly quick. It then gets put to a vote. If the vote is against the proposal, which it could be, then GEMA can override it and approve it anyway, because it's marking its own homework. If the vote is in favour, as it turned out to be, then you have no right of appeal. You only have a right of judicial review, but it was approved because it was, as I understand it, considered to be, the writing on the wall was this is the this is the way of dealing with the mess from CMP 339, hardwiring into the CUSC a legally erroneous definition of the connection exclusion. And that was the error of law. Now, I've indicated from the South Yorkshire case that there is only one legal definition, and it's either right or wrong. Could I please take you to a decision of Lord Justice Buxton in the Lewisham case, which is at tab 24 of the bundle of authorities. This was a planning case, starting at page 1055. You see from the head note, the issue was whether or not a planning authority has properly understood the requirement to give an environmental impact assessment for a particular development, and that depended on the statutory construction of some terms dealing with developments generally. I think it was a very large storage facility that was one of the yellow box companies or something similar. Big yellow property company.
Yes,
1057. At page 1059, you can see it's in the judgment of Lord Justice Buxton. At paragraph 7, the first question for the planning authority had been to determine whether or not the application before it was a Schedule 2 application, which was in the terms of the definition set out in paragraph 5 above, essentially whether it was a substantial business development. And we then see in paragraph 8, in the present case, the only serious contender for a category of Schedule 2 development under which the application might fall is paragraph 10b, infrastructure projects that are urban development projects. These are very wide and to some extent obscure expressions, and a good deal of legitimate disagreement will be involved in applying them to the facts of any given case. That emboldened Lewisham to argue, and the judge to agree, that such a determination on the part of the local authority could only be challenged if it were Wednesbury unreasonable. I do not agree. However fact-sensitive a determination may be, it is not simply a finding of fact nor of discretionary judgment. Rather, it involves the application of the authority's understanding of the meaning in law of the expression used in the regulation. If the authority reaches an understanding of those expressions that is wrong as a matter of law, then the court must correct that error. And in determining the meaning of the statutory expressions, the concept of reasonable judgment as embodied in Wednesbury simply has no part to play. That's not an end of the matter. The meaning in law may be itself sufficiently imprecise in applying those facts as opposed to determining what the meaning was in the first place. A range of different views is possible. So what the judge is there saying is where you have a defined legal term, you have to get it right. If you get it wrong, it's an error of law. And it's only where the term itself encompasses within it some measure of discretion that you would have a different outcome. This isn't, with respect to discretion case, this is a case where the judge here, we say, got it right, and he got it right because GEMA itself recognised that the connection exclusion was wrong as a matter of law. Next authority, tab 22, to similar effect, a judgment of speech of Lord Slynn in the House of Lords in the Mercury case, which I understand my Lord Justice Green was counsel in. So I shan't labour the facts, but if I could turn simply to a very short passage at page 1047 behind tab 22, perhaps to save your Lordship's ears and my voice, if you'd be kind enough to read 1047 from C down to H, and then overleaf A and B.
I can't believe it was 26 years ago.
I wasn't going to mention that, my Lord.
No.
finally, for completeness, I appreciate it's a first instance decision, but in my respectful submission, it helpfully brings quite a lot of these issues into context. And the glamour of the facts simply mean that I feel compelled to draw the case to the court's attention. It's the judgment of Mr. Justice Kerr in the Kingston upon Hull case. The issue was whether or not Greggs providing takeaway pasties had an obligation to provide lavatories for customers, which turned on some statutory construction. In that case, a principal authority, I think in Newcastle, local authority, had issued guidance which came up with a somewhat arbitrary limit as to whether or not, if there were 10 tables or more in the takeaway facilities, it needed to have loos. If there were 10 tables or fewer, then it didn't. Question was that guidance lawful? Could we please turn to page 1075 in his lordship's judgment? And the submission that was made was that even if somehow, see paragraph 50, even if somehow the law was wrong, nonetheless there'd been an informed professional view of the law, and essentially they'd done their best to get it right. Please could the court then read paragraphs 53 through to 59, which summarise the learned judge's conclusion as to why an error of law was an error of law, there was only one meaning, and the guidance was wrong. So that's 53 through to 59. So we say the connection exclusion is a term of law. We say that the ancillary services exclusion is a term of law. Point 2 of Annex B to the guidelines says charges falling within the scope of those exclusions shall be excluded from the numerator of the calculation. That calculation has to be carried out. How, where and by whom that calculation is to be carried out is not stipulated in the Itc Regulation. But whoever does it has to get the law right. GEMA here sanctioned for many years a system whereby with no visibility or transparency, National Grid performed that calculation. And sometimes generators thought National Grid must have got that calculation wrong. And there was then a request for remedial relief in the form of, for example, CMP 261. Having decided in 317 and 327 to put that calculation on a formal and legally binding basis for CUSC users, with the threat of regulatory breach if you don't comply with what the CUSC says. It was incumbent upon GEMA to make sure that they got the legal definitions right. If they didn't get the legal definitions right, that was an error of law. And they didn't get the legal definitions right. Everything that follows after that is a question of, well, what do you do about it from the point of view of relief? And it's been suggested, well, what were they meant to do when faced with 84 proposals? The primary thing that they should have done was to exercise their send-back power to get the parties to have another go. If they didn't want to do that, then it was open to them to reject all of the proposals. They could then do what they subsequently did and direct a modification of their own, mark their own homework and approve it. If they didn't like that or didn't want to do that, they simply could have let sleeping dogs lie. This calculation would have carried on being performed in the background. There would have been no visibility of the parameters that went into it, but National Grid would have been tasked with ensuring that the parameters were met, and it would have been for the CUSC counterparties to work out to what extent they pushed for visibility of that, as SSE is now doing with a further CUSC modification proposal. But all of that is for the future, not for now. The point is that these options were open to them. And for your note, in a different context involving gas charging, that is exactly what GEMA did. That's Supplemental Bundle 1, Tab 9, page 126. There was a gas modification proposal involving UNC 678, which is the gas code version of the CMP process that we
Can you
have.
read the page number again?
Page 126. And in essence, that is a decision that was taken, it refers back to, perhaps turn it up very quickly. I know what's going there.
I think you covered this in your skeleton.
I do, which is why I was hoping to touch on it briefly. But if we could turn to 126, that's the first page of a subsequent decision. If we just note 6 to 7 lines down, there's a passage that begins on the 20th of December 2018. We concluded that none of the UNC 621 modifications were compliant with a regulation that deals with tariff charging for gas, and so could not be implemented. In our decision, we said we expect industry to ensure GB is compliant with the requirements of TAR NC. That's the proper way to do it. Why? Because you are not then baking in an illegality into a legally binding document with licence obligations. You let industry sort out the mess. If they don't sort out the mess, you make a direction.
Is the only difference thereby, under the solution now adopted, there's baking in, whereas under the solution, the status quo ante, there was no baking in, but there was just wholesale disregard.
But there was wholesale disregard as a result of this proposal not being accepted, because there was an obligation.
Is that the difference? Never mind the gas case. Isn't that the difference? You say the only difference you can point to is baking in is bad, wholesale disregard by industry is okay.
Well,
is that the difference?
my
Really?
lord, what was, if I may ask this, what was the wholesale disregard that was going on? Either National Grid was performing its own compliance check conformably with the Itc Regulation, or it wasn't. In terms of setting the ex-ante tariffs, you have my submission that they didn't need to.
But isn't that, call that wholesale regard then? But I'm just wondering what the difference is between the regulatory solution, which is, as you call it, baking in, and the previous situation, which the judge finds is worse, but which is just general disregard, but no baking in.
But, my lord, there was no express connection between the charging structure under the CUSC and the Itc Regulation, save for the ex-ante calculation. And it would have been open to National Grid because there was no definition of connection exclusion at all in the CUSC. National Grid could simply have applied the correct definition to the connection exclusion and said, well, for the purposes of assessing compliance, we're not going to add just the connection charges, we're going to add the tenuous charges. And that's what they did in the intervening period between 2018, when the CMA ruled on what the connection exclusion said and should say, and then proposing their own alternative in May 2019. Throughout that period, there was a a monitoring process going on by Grid, where they were applying the GOS spur to make sure that there was no breach. And none of that was in the CUSC. That was a calculation apart. And Mr. Justice Swift said very clearly in paragraph 43, there's nothing to stop GEMA adopting different ways of ensuring compliance with the ITC regulation. They can do what they like to ensure calculation is correct, as long as the calculation is correct. So there was simply no specific reason why the ITC regulation was breached prior to putting in the wrong legal definition of a legal term into the CUSC. It was always open to National Grid to say, applying the right definition, there is no breach. If there were a breach, it was open to National Grid to say, well, we're going to use an ad hoc ex post reconciliation process to make sure generators pay back the money that they should have paid conformably with the regulation. And they could have relied on the regulation as justification for doing that. Problem solved. The reality is, this was a choice, and this is clear from the GEMA decision. I haven't turned to that yet, and I will need to come back to it tomorrow, I'm afraid. But if we could turn to the GEMA decision, which is Supplemental Bundle 2. Inexplicably, it's in a Supplemental Bundle. Supplemental Bundle 2. Tab 14. If we could turn, please, to page 265 and 266. Bottom of page 265, having considered the various competing options, which were original proposal versus generator-only spur. So generator-only spur was the outcome mandated by the CMP 261 decision, EDF case. Generator-only spurs would then be included in the CUSC calculation, reflecting the proper construction of the connection exclusion following the CMA decision in 2018. At the bottom of the page, we therefore considered that both the original proposal and WACM 7 would be likely to result in compliance with the permitted range for each of the next 3 years. During that period, both options would involve only a small divergence from the correct interpretation of the connection exclusion. Just pausing there. There is only one correct construction of the legal term. See the cases I've cited. And that's why Mr. Justice Swift said a miss is as good as a mile. It's either lawful or it's unlawful. There's only one correct construction. However, from years 2024 onwards, the options would result in significant over or under conclusion of charges in the connection exclusion. But clearly, on GEMA's case, they weren't expecting this to last as long. So it's then a straight choice. You've got a straight choice between the two next bullet points. Treating too many charges as falling within the connection exclusion could lead to a breach of the upper threshold of the permitted range. In terms of commercial drivers behind this litigation, that's bad for generators. It's bad for generators because generators then, as a class, face higher charges than they otherwise would do. Why do generators care about that? It affects their competitive position with other generators in the EU. And that is very damaging for GB generation. Ultimately, generators will probably recover their costs if they're commercially astute and profit-making from their customers, and in due course, those customers will recover them from final customers. That isn't going to change. What changes is that GB generation are facing higher costs than their counterparts in other EU countries who don't have a tariff window which goes as high as 2.5 euros per megawatt hour. They only have 0.5 megawatt per megawatt hour as a limit. So we already face a higher cap than our EU counterparts. And we face a competitive disadvantage if we have to face and pay higher charges than are properly due. That's what's driving this. The alternative, sticking on the generators, is to stick it on suppliers who ultimately are going to bear the cost via the final consumer is going to pay the cost in due course anyway. We then see, while treating too few charges as falling within the connection exclusion would not be expected to result in a breach of the lower threshold, it would result in demand consumers facing higher charges than would otherwise be the case. So it's a straightforward fight between generators and consumers, and GEMA came out in favour of the consumer. But in doing that, whereas previously there was no unlawful definition of connection exclusion in the CUSC. Following this decision, there was, and that was the illegality. My Lords, I have a handful of points to make on grounds 1 and 2, which are somewhat merged in the course of my submissions, and then I move on to the cross appeal. I'm happy to finish grounds 1 and 2 so that we're done on that for today, or I can.
Well, you think you can finish those by 4:30?
Oh, easily, yes.
Okay.
I think the final point I need to deal with is that the allegation that this all causes a mess, chaos, practical difficulties. What's the point when you can simply kick the can down the road for a bit and it will cure itself in due course? The answer to that is to be found in a judgment of the Court of Appeal in Ex parte Pici. That's Bundle of Authorities 2, tab 18, page 842. So that's Bundle of Authorities 2, tab 18, page 842. It's a judgment of the Court of Appeal consisting of Lord Denning, Chancellor Rolls, Lord Justice Dankwitz, and Lord Justice Salmon. The particular point that I'm seeking to derive comes not from Lord Denning's judgment, but from the judgments of the other two Lords Justice. Could I pick it up, please, at page 880 in the bundle? Now, there was a difference of opinion between two of their lordships and a third as to whether or not there was in fact an error of law. So the majority found that there was no error of law in the valuation list that the planning authority approved. Now, the planning authority's valuation list came up with wild discrepancies between the rating value of ordinary flats in houses and then the rating value for large blocks of flats for reasons that weren't entirely clear from the factual findings made. But we then see in the judgment of Lord Justice Dankwitz, page 880, B to C, that he had reached the conclusion that the valuation list was wrong in law and should not be allowed to stand. He then therefore thought the court should put in place both mandamus and certiorari in order to give effect to that illegality, which would involve quashing the existing list. Now, on that point, he parted company with Lord Denning, Master of the Rolls, and Lord Justice Salmon, who took the view that it was appropriate to issue mandamus, but not to issue certiorari until such time as the list had been rectified. So that's the relief point. But the question in principle is, should you fight shy of declaring illegality and dealing with an illegality simply on the basis that it would cause chaos or practical inconvenience? And his lordship said at C to D, it may be that the questioning of the valuation list for the Borough of Paddington will affect not only the whole of the rating valuations in that portion of Westminster, but also the valuation in London and possibly England. But inconvenience that may be caused by that way does not seem to me to a justification for ignoring invalidity, and a way of preventing any chaos that might be created in that way has been suggested. Turning over the page at page 881. Lord Justice Salmon declined to express a view on whether or not you should suspend certiorari so that mandamus only would issue following the writ. He expressed no concluded opinion on that, page 881 C to D. I would add that whatever inconvenience or chaos might be involved in allowing the appeal, the court would not be deterred from doing so if satisfied that the valuation officer had acted illegally. So if the valuation list on his findings had been unlawful, he would have issued appropriate relief to make it clear that that illegality could not be tolerated by the court. So there's a vexed question of relief, but the fundamental point running through both those judgments is mere questions of chaos or inconvenience don't excuse an illegality. And so here we say, with respect, the whole issue of whether or not there were other things that GEMA could have done, in a sense, is a secondary order consideration, because the reality is they should not have adopted an unlawful definition. The final point, I think, is just on ACOs. I understood from my Lord's questions to my learned friends that they weren't terribly impressed, if I can put it this way, but the suggestion that if you are making a decision that's unlawful, it can nonetheless be excused if it's a question of evaluating what might be better. If I'm wrong on that, then I repeat the submissions I've already made, that this is a question of law, it's a legal term, you have to get the definition right. There is only one construction. Evaluation and discretionary judgment don't come into it. Whilst the ACOs, the objectives, as a matter of contract under the CUSC, require GRID to weigh competing considerations when deciding whether or not to make a modification proposal, and then GEMA is required to weigh those competing considerations when deciding whether to approve it. The short point is it cannot approve an unlawful construction of the ITC regulation. And so, regardless of what the position may be as a matter of the contractual arrangement.
It's just a refinement of the principle you just showed.
Yes, exactly. Which is,
as it were, remedy the chaos by doing something unlawful.
yes, or indeed, it's a hard-edged question of law, it's not a question of discretion, is the other way of putting it.
Can I turn this question around just for one moment? We've been looking at this as if it's a clean piece of paper analysis. We start, and the common ground starting point is that there was an unlawful definition. And therefore the issue is perhaps not so much whether it was unlawful, it's how do you get out of it? And there's a duty under Article 17 and 18 of the 2009 regulation, which imposes an obligation on the regulator to both comply and ensure compliance. So it says we're going to do that by moving away from the unlawful situation in 2 stages. A fortiori, there is perpetuated illegality as you move out of it. The ACO obligation includes better to facilitate. If you're in a, if you like, a remedy or a relief situation, I mean, are we applying the right optic? Are we not saying it's a get-out situation? It's how do you get out of illegality? It's obvious that there's going to be a degree of illegality as you move out of it, because in this market you can't do anything overnight. So you're going to perpetuate something.
My lord, there wasn't any illegality prior to CMP 317327, because all you had was the self-standing application of
Well,
the
hang on a
ITC
minute.
regulation.
I thought you were telling us there was, in the sense that National Grid was misapplying the definition of connection exclusion.
And we've got the CMA decision of 2018 saying that there's in this system there is a misdirection of law. So we're starting with a situation of non-compliance. You're moving into compliance. Along the way, there's bound to be some, if you like, diminishing level of non-compliance until you get to part, point 0, where you're in compliance. Because we're not looking at a continuing situation, we're looking at a remedial situation, moving out of a given state of illegality into one of adherence. And that's why this question is, you know, one's got to, it's a difficult question really to frame it's difficult to frame what the question is. It is moving out of illegality into legality, and how must the regulator act in those circumstances? And it's always going to be a given that there will be a period of time in which you get diminishing levels of non-compliance, yet still non-compliance.
My lord, there was no illegality prior to 317327. May I very briefly explain why? True it is, in CMP 261, we had said there's a breach of the upper cap. The answer from GEMA was no, there's not, because actually the connection exclusion includes GOS, and that's the way we're calculating. No illegality as it stood, because GOS was the additional bit that needed to be added in. The CMA ruled that GEMA was entitled to take that approach. One assumes thereafter that National Grid, when it was conducting this invisible, untransparent exercise of working out whether there was compliance, followed the CMA decision, and I've got no reason to suggest otherwise. If that's the case, there is no incompatibility between what was done in terms of the ITC regulation and what was done in terms of the CUSC, because it was a separate exercise to work out whether or not there was in fact an infringement. And we've got nothing to say that that exercise was done unlawfully. There's simply nothing there. As soon as you bake in to the CUSC an unlawful definition, you do have an illegality.
But the judge's premise was that there was something wrong. That's the judge's premise.
The judge's premise was that the ex-ante calculation was producing
It was more likely to result in breach.
was producing a view of tariffs which was unnecessary, because in fact it was being done to comply with the limit. The illegality there was not the ITC regulation and non-compliance with the ITC regulation. the perceived illegality had not in fact taken place. It was premised on the idea that National Grid would include within the connection exclusion only those connection charges under the CUSC. That was the premise. But actually there is no indication that that is what Grid was doing. And the only obligation on Grid was based on the ITC regulation. There's nothing in the CUSC that required them to state in their ex ante calculation that the connection exclusion is connection charges only defined by the CUSC and nothing else. So it was open to Grid when performing that ex ante calculation to plug in not only offshore GOS but any other charges.
Didn't the regulation apply to National Grid? It was directly applicable.
National Grid would have been bound by the regulation, we say. There's a vexed question as to whether or not it's a sufficient state body to be bound by.
Whether it was complying with the code or not is neither here nor there.
There was nothing in the code that said the connection exclusion equals only connection charges.
The fact that they adopted what you say was a wrong definition in law in CMP 339 is a fairly good indication, isn't it, that they were misinterpreting it previously. But I think you told us a while ago that a number of your clients were concerned that they were misinterpreting.
The concern was there, but one has to assume that they would then apply. That's why CMP 261, the CMA found against my client, so we lost, and we didn't seek judicial review. So we've lost on that point, and one assumes that National Grid, when it was exercising its compliance monitoring task, was thereafter applying the correct definition of the connection exclusion. But the point is, nothing was hardwired anywhere into any domestic provision. So there was nothing impeding the full and whole application of the ITC regulation itself. That was a directly binding EU law measure, which everyone had to comply with. It's not being suggested that they didn't comply with it. What changes in CMP 317 and 327 is that you do then build in something that doesn't comply with the ITC regulation. And that's the first breach.
Well, let's break for the day and we'll see you at 10:30 tomorrow morning.
Court Morris.